Welcome and thanks for joining us on Work Comp Matters videos, where we interview experts in the field of workers' compensation, employment, and labor law. We're, of course, brought to you by WorkCompCentral.com. If you want the #1 online location for all of your workers' compensation needs, including but not limited to news, employment, credits, and blogging, check out WorkCompCentral.com. And as always, we're brought to you by A1 Law. If you want the #1 computer management system used by more workers' compensation attorneys than any other system in the Kuiper Belt, give me a call at 818-357-4120 for your no-strings-attached money-back guarantee, $1 a day, A1 Law. This week we're here with workers' compensation attorney Saul Allweiss, and we're talking about alternative dispute resolution and carve-out. Saul, welcome to the show.
Thank you, Steve.
It's a pleasure to have you here, so let's just get right into it. Can you please tell us what is alternative dispute resolution?
Sure. Alternate dispute resolution, or ADR, has been around actually for well over 20 years. It allows any union and management team to carve themselves out of the workers' compensation world. And there are almost no limitations to it. There's one very significant limitation, and one is that you can't agree to lower benefits. So the unions and management can't shake hands and agree, well, we're going to create a bonus program and lower TD by 15%. They could raise benefits, but they can't lower benefits. So ADRs can take, so in order to become an ADR, a union and a management team say, let's put this together. An ADR can take many, many shapes. The most common shape that an ADR has is involving a litigation system that is hopefully more efficient than the WCAB. Many times it includes something actually stronger than a medical provider network. It might include what's known as an exclusive list of medical providers. Most ADRs include an alternative to the QME process, and usually has an agreed list, and this is agreed between management and labor, as to who will be the medical legal evaluators.
I know that the last time I was involved in an ADR carve-out, each side was able to pick our own doc. Is that still the case?
No. There are some ADRs that allow that to happen, but there are some ADRs that have their own distinct list of, let's say, 60 or 100 doctors, and the parties can try to agree from that list, and if they can't, then the ombudsman selects who the medical evaluator is going to be.
Please continue.
So, the new concept, ombudsman.
And that's what sorry for interrupting, that's what I wanted to get in. What is the difference between an ombudsman, an arbitrator, and a workers' compensation judge?
All right, so the ombudsman is not a workers' comp judge, mediator, or arbitrator. The ombudsman oversees the entire program and works as the administrator of the program. The ombudsman is going to be controlled by the rules of the program, but for the most part, what the ombudsman does on non-litigated cases is, at the start of the case, they send the injured worker a notice saying, hey, I'm the ombudsman. If you ever have a problem on your claim, give me a call. The injured worker's TD is cut off. They can give the ombudsman a call, and the ombudsman is going to call the examiner and find out what the hell's going on here.
So clearly there's no such thing as ex parte communication with the ombudsman.
No, the ombudsman is allowed and encouraged to have ex parte communication.
He's encouraged to have it. Okay.
Yeah. So now, but when it comes to litigated cases, the ombudsman also intervenes in that regard. So the ombudsman is going to tell the parties, okay, we have a medical legal dispute. Here's the list of agreed doctors. Can you guys agree on it? And if you can't, I'm going to pick the doctor.
Okay.
So in a classic ADR system, what happens, anytime there's a dispute, the party having a dispute takes it to the ombudsman, and the ombudsman tries to resolve the dispute. If the dispute can't be resolved, Most ADR programs allow the case to go to mediation. Mediation can occur face-to-face, mediation can occur telephonically. When a mediation occurs, if it's to settle the entire case, then the mediator is there to try to resolve all issues. If it's in regard to maybe just a dispute as to discovery, that's going to usually be a telephone mediation, and they try to resolve that. Mediator has quasi-judicial authority. They can't do a trial, but they can issue orders, and they can direct the parties in terms of timeframes as to when they should be performing various things. Also, they can approve settlements.
Is there an appeal process for the ADR if you don't like the decision?
Well, let's stay with a mediator. So if a mediator does something that's totally out of line, this is kind of akin to a MSC judge. And if the mediator does something totally out of line, a party could actually take a petition for removal to the WCAB. So the appeal rights are the exact same as they are at the WCA, if you were at a local DWC. Now, when you go to arbitration, that's a trial. And the court reporter is going to be there, they're going to take testimony, and they'll issue a findings and award. And if you're not happy with that, it's the same rights of appeal. Petition for reconsideration, District Court of Appeals, Supreme Court.
Of course. It seems like the ADR process moves a lot quicker than the WCAB. Is that an accurate statement?
Very, very quickly. And the ADR process is designed to take all of the friction away from the system. When you go to a mediation in an ADR or an arbitration, it's the only case set that day. Mm-hmm. So
there are no continuances.
No, there's no such thing as a continuance. Mm-hmm. And in mediation, the parties, I do a lot of mediations, mm-hmm. and I pride myself on my settlement rate being well above 90%.
Mm-hmm. Congratulations.
And it's because I really hold the parties' feet to the fire and saying, you belong to me for the next 4, 6, 8 hours, however long it's going to take, and we're going to try to settle this case. And we usually have good results.
Well, based on what you're saying, it would seem to me there's no reason not to be in a carve-out or an alternative dispute resolution. Are there any bad points or reasons not to be in the ADR carve-out?
Well, some of the early ADRs, the ones that were around in the early 90s, involved construction trades. This was around roughly for around 8 or 10 years, and they actually prohibited applicants' attorneys from participating at any point in the process short of arbitration. They couldn't get involved until then. So, but that is a very, very small fraction of the current ADR programs that are out there. I've been involved in every aspect of it. I've created ADRs. I created a very successful ADR for Vaughn's, which is now owned by Albertsons, and mm-hmm. It's been around for 6 or 8 years, and both the unions and management is extremely happy with that program. I also work as a mediator in a number of ADR programs, and I'm an advocate where my client is in an ADR and they're asking me to represent them on certain claims.
What percentage of all the workers' compensation cases in California are in the ADR carve-out?
It's probably very small. I would say less than 5 or 10%. But there is a lot of interest. The city of Los Angeles, this past couple of years, they brought all of their non-sworn personnel into ADR.
What is a non-sworn personnel?
Non-sworn is everybody except for police and fire.
Okay, gotcha.
The police came into their ADR, into a separate ADR last year, and the fire department unions are currently in negotiations with the city of LA management in regard to forming an ADR for themselves.
Now, I know that all of the workers' compensation attorneys that are watching this know that the fire department, the police department, they have the presumptions. The firemen and policemen have those presumptions that regular workers' comp employees do not have. Do they maintain those presumptions?
Yes, because to take away those presumptions would be a reduction in benefit, and that's the mm-hmm. one rule of the road. So I'd like to, recommend to people seeing this is the first thing you should do if you're an applicant's attorney and you've been told you're in an ADR program is call the ombudsman up. And one of the things you should ask for is a copy of the ADR agreement so that you know what the rules of the road are. Some ADRs actually have their own sets of rules and regulations.
Do they need to be approved by the state of California?
No. The ADR program itself overall is approved by the state of California, but not necessarily the ADR agreements and the rules and regulations. So what will happen in those and actually applicants' attorneys should know that in many ADRs there is an agreement to not utilize utilization review or independent medical review.
Really?
Yes. And in most ADRs that I've seen, it's what we had before IMR, that if UR is still done, but if there is a dispute of the utilization review from the applicant, it actually goes to a medical legal evaluator. Not
So it does
IMR.
not go to IMR?
Now this depends on, this varies from ADR to ADR, but I could tell you that in a number of ADRs, IMR, UR is still around, but IMR has been taken out.
Mm-hmm.
So your first step is to, if you're an applicant's attorney, to get yourself
Familiar with the rules?
Yep.
Sure.
And also ask what type of unique forms there are. The ADR might have provisions for raters. It might have provisions for what's known as nurse advocates, which are independent nurses that are hired to help solve medical problems.
Now, of course, we would refer to that in workers' compensation as a nurse case manager, but this is something different.
Well, this is something I would suggest is far more independent because the nurse case manager is acting at the direction of the ombudsman.
Okay.
And as a result, not the nurse case manager, the nurse advocate. So it does. So you have to find out what is unique to your ADR program. You want to ask, is there an MPN or is there an exclusive list of medical evaluators? And if there is, give me the list. You want to know if I have a medical legal dispute, who are the medical evaluators, or the ADR you referenced. There are some ADRs out there that just let each party pick their own. Mm-hmm. Once again, you got to know the rules of the road.
Right.
The other thing that applicants' attorneys should be very wary of is if there is appropriate jurisdiction of an ADR program, meaning the employee is a member of the union that is part of this, this agreement between management and labor, if they filed a case before the WCAB, they're going to be asked to dismiss it, and I would strongly recommend that they do.
Why waste your time and spin your wheels when it's not going to go anywhere?
Well, yeah, and if you don't dismiss it, you're really going to get the ombudsman pretty upset and the defense pretty upset. The other interesting area that would involve defense attorneys is, so what happens if there's a cumulative trauma claim and I represent an employer that isn't involved in the ADR process? Mm-hmm. And the answer to that question is, well, you might be invited to voluntarily submit to ADR, but that is you have to voluntarily go in. If you say no, you're going to probably create a significant nightmare for the employer.
I would say everybody, but
yeah, because you're going to end up litigating. The applicant is going to have to end up litigating the case on two separate fronts, and the ADR defendant is going to have their hands full in trying to coordinate everything. Because I'm a big proponent of ADR, I'd recommend, opting in, because even if you're not in a specific ADR program, because I believe that it's a more efficient process, and as a defendant, you'll like it even though you're not technically part of it, but you can opt in.
We've only got about a minute left. What does it take to be an ombudsman?
There's no technical qualifications. The ADR agreement could create qualifications for who an ombudsman might be. So, but otherwise, it's just somebody that union and labor agree to. And also, who are the mediators and who are the arbitrators? that's an agreement that goes between labor and management as well. They create an agreed list of mediators and arbitrators.
Saul, I really appreciate you coming in. My name is Steve Appell. You've been watching Work Comp Matters videos. We're brought to you by A1 Law and WorkCompCentral.com, and thanks for listening.